Isn't there any law that clarifies what happens to movable abandoned?
Yes, for movable, yes. I can tell you, I read in the Egyptian law and in many other laws, if you decide that you don't like your refrigerator table, it's the small table in the corner, you don't like it, so you carry it and you put it in the street. This is abandoned property, and anyone else can come and take it, and this is very legal. So the owner is the possessor, the one who have it now, the possessor.
Find the keepers, yeah.
So, and you can find this, I don't know about the US, but you can find this in Europe. In certain occasions, they decide that they don't like some of their furniture, so they just throw it away. Mm-hmm. And I saw this, they just, and some of them are really very nice ones. And if you're, especially students.
Yes, I know.
Oh, this is very nice table. It happened before. A very nice refrigerator table, and I was working with one of my friends in The Hague when I was studying there. And oh, this is very nice. You can take it? Yes, sure. Take it with me. And she took it because this is abandoned property. But can we do the same? This is for physical property. Can we do the same for things related to intellectual property? No. So this is the issue. No, because of the moral rights, you can't do this.
This is a great question. Yeah. This is a great point, the difference between physical and
Yes. Yes.
So if someone writes a book or half a book and then decides that he doesn't like it and he throws it away, and then someone finds it and then edits it or edits on it and then republishes it. No?
This is infringement.
No, so it's different then.
Yes.
It's a different case from the stuff that
but still the 143
more right. Yeah.
The right to make it available to the public for the first time. But if you make it available to the public for the first time, then you can claim it. It's a 143. The moral rights, number one. Number one. 143. Yes. The right? Yeah. For the first time. If you made it available for the first time, it's okay. But if you decide that, even if it's something really brilliant, even if this painting was really great, but unless he gives you the permission, you can't. According to the moral rights. This is, and it's not only about moral rights, it's about the difference between the property, physical property, movable and immovable, and the intellectual property. And this is take us back to this point that intellectual property is not normal property. It's just an artificial legal tool to give incentive to creators for a limited time. If we go back to the American Constitution, yes, here. Limited time, huh? Mm-hmm. Limited time and exclusive rights, and this can take us.
So if this case had happened in America, they would have, the gallery would have won?
I'm not sure.
I don't think so. I think you
sure.
will get into
I don't
the
think
case
so
of
because
contributory.
the American, they already have moral rights, but it's not for.
Yeah, the moral rights are not strong. But this
right.
reminds me. Remember the case of the fair when there was a fair and there was something, in the market and so on. So this would be a similar case, and we cover this under contributory and vicarious interference.
But in Egypt,
So in Egypt, the moral right would preside.
Like I don't know, maybe it was a fair use lecture or in the very beginning, Dr. Fisher talked about how the author has all rights over their own work and they can do whatever they want to it, and even if it was a commissioned work, they can choose to take it back.
Mm-hmm. The right to change your mind. It's also in the Egyptian law.
yes,
the right to change your
they
mind.
can. But then if maybe they have in this point, they have to pay some
They have to
compensation.
pay, exactly. Same with the US.
And most of the time, maybe they can do this through the court. It's somewhere here.
Yeah, they have to pay compensation, exactly.
Yes, it's 144.
Okay. Put it up?
If you can check it later or you can see it now, but it's 144.
Okay.
What I want you to see here, just burn, because the legal language is very accurate, and you need to see that every word is meant to be. So here in Berne Convention, Article 9, this is, we can say this is the mother, or this is the most of the exceptional limitations. And you can see exclusive rights and author. This is Berne, 88 something. And this is TRIPS. You see the difference? You see the difference? Right holder. See?
So what is the difference between right holder and author?
This is Berne.
Yeah.
The right holder is the publisher in
Whoever. Whoever. And think about Berne. It was mainly, I believe, it was born in under the civil system, civil law, something like this. But TRIPS is something. It's under the WTO, World Trade Organization. So the main point with the World Trade is about trade. So this is why their concern is about the right holder, not necessarily.
And there are different times too, and I think you would see the word global powers, in the 1800s is one thing, and then
There's something to think about it, but when you read
very important.
any legal text, you need to read every single word, and every word has a meaning. And at the same time, if you go back to the Egyptian institution, yes, I'm not happy with the wording. However, you need to read the whole constitution from the Article 1 to Article, I believe, 200 something. So if you read the whole constitution, and this is what the legislator or the coming parliament should do, you'll find they say there is a mention for intellectual property once or twice, but there is a mention for the education, something 20 something. There is a mention for research and scientific research 5-6 times. So if they want to protect intellectual property, they need to read the whole constitution, all the articles, to get the philosophy behind why we are protecting intellectual property.
Which doesn't
It's
show
not-
in the article, right? Which doesn't show in the article.
No, this is my problem with this article, because it's not that clear as the American one. However, if the coming parliament, the legislature, those who will write the next new IP law or the amendments to our current law, legislation, they need to read the whole thing, and especially in the Egyptian law. I believe it's in this chapter about rights and obligations, and it's in the same. There are many articles about the scientific research, creativity, even if it's not mentioned in the article itself, but I believe it's mentioned somewhere in the Constitution. So if you read any legal document, a contract, you need to read the whole contract. If you read a convention, constitution, read the whole thing. Don't just take part of it. And here I believe can stop. And if you still
So what is your judgment on the case? Are you going to give us your judgment?
Yes, the gallery can't do this. They are really liable. They are breaching the law, the copyright law. They are breaching the moral rights of the artist. So and they can't display it. And even according to 181, in fact, there are some criminal. In 181, there are some criminals. Some criminal.
Hala? Can you pull out the law again?
181.
181.
Clear, even according to 181, there are some criminal penalties. So no, he can't.
Okay, now just to make sure that everyone, yeah. I think there are questions.
Okay, as far as I understand, moral rights cannot be waived.
Yes.
How does that fit with the objective of Creative Commons management?
Do you think there is any conflict here?
Yes.
Wow.
Because
Tell me.
if you have the right to do derivative works of whatever you want, and I sign the contract saying that you can, I can, as the moral rights holder, can object to the way you used my work.
Okay.
And that kind of goes against the whole license and whole you have the freedom to do whatever you want.
But if you give me the permission to make some changes on my work and have a new work based on my original work as a derivative, then there is no infringement. I give you the permission to do this. Let's say I wrote a novel in English and you like it so much and you want the Egyptian to read it in Arabic. So either you got my written permission or I put it under Creative Commons derivative work are allowed.
My question, if I can modify your questions, the question would also apply to copyright.
Yes.
You see what I'm getting at? And maybe this is something we can ask Hala. So Habiba is saying, doesn't this weaken CC? My question is the same thing. But that's the thing.
The right to prevent any modification considered by the author as distortion.
Mutilation.
So this is the example I gave you.
But Hala,
Who can decide? Then we have to go to the court.
but what I'm saying is the point holds regardless of what copyright system is there, may that be CC or the copyright law. Yani the fact that it's Creative Commons doesn't put the issue in a stronger light. It's it's another different type of license. You see what I mean?
It's another
The issue is there anyway.
Treat Creative Commons as a contract.
As a type of copyright.
Don't think about it. It's another system or it's a new law. No, it's a contract.
So even
Based on the current copyright regime.
So even like in the case of Jay-Z, even if somebody through the copyright law gives a license through the law and everything, and they find that it's mutilated, they will file a case for more.
And three is very, I believe, they answer your. Yeah.
So should I go back to the author to prevent any conflict? And
Who
before
are you?
I'm the one who will do the dirty work.
Come again? I can't hear
I'm
you.
the one who is going to do a dirty work.
You're the one who's going to do a derivative work based on a CC license or on a CC license?
Yes.
So the one who is going to create a derivative work. If you have the license to do
I go
derivative,
back
you don't
to-
have to go to the author.
No, I mean, but no, like he means regardless, then instead of getting the permission for doing a derivative work, get a permission for the work you're gonna do, because
Not necessarily.
Yeah.
Not necessarily.
You mean do it amicably with it, make
Yeah,
sure that
prevent any
Yeah.
conflict.
I see what. Why not? Yeah, the question is, should they check with the author and say this is what? So
If they
I
want,
want to
why not? But my novel, I give you the permission to translate it. You translated something else. I'm saying that you made a real change that's different than what I meant. Then I can stop it, although I give you the permission. You took my novel and made a film and made the bad guy someone else. This is not what I meant. I can stop you.
But what
Although I gave you the permission, but not necessarily everything you do, then you go back. This is perfect, but not necessarily you go and everything you change in my work, in your derivative work, you go to the original author to check with him or her.
But what he's saying, I think Basil is suggesting, is this a good idea to prevent conflict? To sort of
Yeah, why not?
prevent-
If this is available, why not? But I don't think it's always
nothing, why not? Why not? Yeah.
It's like writing the contract. So you have A, B, and C, and you agree on A, B, and C. If you don't, then you don't write the contract in the first place, or no? It's how they. يعني على ما اللي فهمته إنه it's like writing a contract. The contract you have band 1, 2, 3 and 4 وهكذا. It's agreeing on all of them. ولا you could agree on 1 and 2 and 3 but you could leave 4 and 5 out.
No, as we any legal document should be treated as one piece. So, as we said, we read it and we apply it from the beginning to the end. You can't say that, okay, if you breach any of the contract items, then there's a breach of contract.
Any questions, comments? Please join me thanking us. Thank you so much. We've all learned a lot, including myself, everyone.
It was really a pleasure and it was fun.
This is someone, you know, what, on the ground, the real thing, you know, and I think through the course, because we had one guest speaker, you know, Marianne Puri, who was wonderful. She's a veteran producer, director, and she talked to us about the movie business and the movie industry and how it works. So it's nice to get different perspectives. You get the perspective of the, you know, sort of the producer, the, you know, industrial side of it, the commercial side of it, which is important, but you also get the perspective from, if I dare say an 8, okay, you know, allow me to say that because we're finishing the course, so
say it loud and clear. Of course, say it loud and clear.
So this, I think, is good because you have a balance.
I'm the poor lawyer, the lawyer of the library and the users. On the other side,
no, so and the academics, so I'm the poor. Yeah. So thank you very much.
Thank you so much. Thank you for.
So in the meantime, if you allow me very quickly, I'm going to talk about the final exam. As you know, we have